Kireeva against Bedzhamov.
Lord Richards will explain this judgment.
The respondent to this appeal, Mr Bedzhamov, is a Russian citizen who left Russia in 2015 and has lived in England since 2017. In July 2018, he was declared bankrupt by a court in Moscow, and the appellant was appointed by the Russian court as financial manager, a position equivalent to a trustee in bankruptcy under English law. Since 2015, the respondent has owned a property in central London. As a matter of Russian law, the property is an asset in his bankruptcy, and the appellant is, under Russian law, charged with the duty of taking control of it and selling it for the benefit of creditors claiming in the bankruptcy. Although the respondent had left Russia well before the bankruptcy order was made, he participated to some extent in the proceedings leading to the order and thereby submitted to the jurisdiction of the Russian court. On that basis, under English common law, the English courts will recognise the Russian bankruptcy order and the appointment and status of the appellant as the financial manager in the bankruptcy. An order to that effect was made by the High Court in 2021. Although as a general matter of English common law, the English courts will recognise the appellant's claim to the respondent's assets in this country owned by him as at the date of the bankruptcy order, the issue on this appeal is whether her claim to the property in central London will be recognised and enforced. This issue arises because the property, being land, is categorised as immovable property. There is a long-established principle in many countries, including the United Kingdom, that all rights to immovable property are governed by the law of the country in which the property is located, and that orders of foreign courts dealing with rights to such property will not be recognised. This is known as the immovables rule. The immovables rule applies to a foreign bankruptcy as much as to any other foreign law or foreign court order. There are two statutes which exclude the application of the immovables rule to foreign insolvencies, but it is common ground that neither applies in the present case. The appellant argued that the English court could nonetheless, at common law, provide assistance to a foreign trustee in circumstances such as these by appointing a receiver of the property with power to sell the property and remit the sale proceeds to the appellant for distribution in the Russian bankruptcy. A number of submissions were made in support of this argument, including that the principle of modified universalism enables the court at common law to give this assistance. For the reasons stated in the judgment being given today, the court unanimously rejects the appellant's case. The court holds that all the submissions are incompatible with the immovables rule. In particular, the principle of modified universalism as a basis for assistance is subject to substantive rules of English law, which include the immovables rule. The appellant argued that, if necessary, the immovables rule should be modified so as to enable the English courts to provide assistance to a foreign bankruptcy trustee and thereby promote cooperation in international insolvencies. The court holds that any change in this long-standing rule is a matter for Parliament, not the courts, all the more so as it concerns territorial sovereignty, and exceptions have already been made by legislation. The appeal is therefore dismissed.